Welcome to this free immigration help channel. Today is June 24, 2023, and we are getting into the volume 125 of me answering your immigration related questions. As always, before beginning this video, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first comment from Oracle 3875. Oracle, thank you very much for another comment. Appreciate that. So Oracle says, hello, thanks for everything. You're very welcome. Thank you for watching. I filed for a family of 4. My wife and 3 kids. My wife and 2 young kids have been documentarily qualified. It's left with my older daughter. She is under 21 anyway. Oh, so she's under 21. Okay, NVC sent me a message for her to submit her DS-260 affidavit of support and financial documents, which I already submitted when submitting for all of them, but still don't know why my daughter is not documentarily qualified. Please, what would be the problem and what should I do? Please, thanks. Oracle, so I wanted to ask, how long ago were your wife and the other 2 children documentarily qualified? Because most of the times documentary qualification before they get to reviewing your documents takes about 3 to 4 months. I've seen some cases where it takes a little bit longer, but in most cases they review it within 3 months, and if everything is good, they documentarily qualify you. If something is missing, they come back and say, hey, this is missing, we need something. So it might be just that your wife and your other 2 kids have been, documentarily qualified faster than usual, which is really good thing. It's definitely a great thing. And now they're just waiting to review your other daughter's documents. So if it hasn't been 3 months yet, if it's only been a few weeks, if it's only been a month now, I would recommend giving them more time. If you don't hear back from them in about 3 months, then yes, you can definitely submit the public inquiry form with the NVC and follow up and see why it's taking a little bit longer. But it's definitely, it's nothing unusual. That's what I'm trying to say. So there's absolutely no reason to worry about anything. Just, patience, like with most of the stuff whenever it comes to the immigration process. But on the plus side, you have most of everyone documentarily qualified, which means that everything that you have submitted initially was good. So it should be the same for your other daughter that is not documentarily qualified. So I'll just give it a little bit more time, Oracle. Just a little bit more patience. Okay, let's move on to the next question from Midnight 7777. My petition I-130 for F4, so siblings of US citizens, was approved on March 2011, and my priority date is July 2010. Okay, my petition was sent to NVC, but I never got a welcome letter. I did research online, and I keep finding mixed information. Some people got their welcome letter not too long after it was sent to NVC, and some people got the letter when reaching the priority date. Which is true? I have yet to receive a welcome letter. Okay, Midnight 7777. It's a great question. Thank you for asking. So yes, unfortunately, I don't know why it happened. And it doesn't seem to be the case anymore. It seems that most people that are filing kind of as of recently, NVC is waiting closer to the availability of the immigrant visa before they open up the full access to the NVC portal. But yes, I have also heard of cases where even when the immigrant visa was not available for years ahead, NVC would open up the portal and people were, starting their documentary qualification process, which is a little bit strange because if you are documentarily qualified, years back and now 5 years, 6 years down the road, you have to go for an interview after the immigrant visa becomes available. Obviously, all that information that you submitted during the documentary qualification process is now out of date, which is, it's not very good. It's very likely to create confusion. You're probably gonna need to bring all the updated documents anyway for an interview, so it kind of becomes a mess. So in your situation, I would say it's not a bad thing. I mean, it's not necessarily a great thing because you're waiting for so long and you're still kind of, you feel like you're in the air. But it's definitely not a bad thing at all. So let's take a look at the visa bulletin, F4, force preference category, and see when the NVC, according to the visa bulletin, when the NVC portal is supposed to open for you. So we know that your priority date is in July 2010. So let's take a look at the visa bulletin. You don't have your welcome letter from NVC just yet. So we're going to be looking at the graph B, because graph B is what shows us when the NVC portal is going to fully open up so that you can start documentary qualification process. So right now, according to July 2023 visa bulletin, for F4 category for all chargeability area, which is rest of the world, except 4 countries, China, India, Mexico, Philippines, it is March 2008. So people with priority dates in March 2008, right around that, March 2008, are now getting the full access to their NVC portals. You are in July 2010. So you're looking roughly at another 2 years before you get the welcome letter from the NVC, before the NVC portal fully opens up for you so that you can start documentary qualification process. And then from then on, about a year more before the availability of the immigrant visa. So you see the benefit of waiting closer to the availability of the immigrant visa, because if you documentarily qualified in 2 years, and then just another year, and then you have your interview for the immigrant visa, all the information that you are documentarily qualified with is fresh, and it's the same information that you're going to bring, same documents that you submit to the NVC, you will bring for an interview, show it during the interview. There's, of course, there's possibly some updates might happen within a year, but most of the times it's all the same stuff. So again, it's a wait game, it's patience, but there's some benefits to it because it's all the same documents that you're becoming documentarily qualified with. So in your situation, nothing to worry about, just a little bit more time to wait, and you still have 2 more years to become documentarily qualified. But I would recommend checking out actually this video right here, documentarily qualified, what does it mean, if you haven't seen it yet, what is entailed in the documentary qualification process, and I recommend it to everyone who have not been documentarily qualified yet, so that once the NVC portal opens up, you already know what to expect. You have all your documents put together. You just log in, you pay all the fees, fill out the applications, submit the documents. That's it. Wait for your documentary qualification to be complete, and then wait for the immigrant visa. Okay, moving further to the next question from Sassy Can Apaka. Do we need to keep separate cover letters for I-539A or just a single one addressing both I-539 and I-539A? Great question, thank you for asking. Yes, just one cover letter is fine because you are submitting a one application package. It's going to be your I-539, I-539A, and then your cover letter you can put right on the top, or you can put in between the I-539 and I-539, or you can put it at the very end. Honestly, whenever it comes to the cover letters, I like to put them at the very top, just so that the immigrant officer does not miss them, and the very first thing they see is the reason why you're requesting the I-539. And in there, obviously, you will mention that it's not just you're requesting the extension of the visa, of the visitor visa, but for somebody else. All right, so let me post the response here, and we're gonna move on to the next question from user HV3LH2MR. Sorry, for some reason YouTube decided to show handles here now instead of the names, so apologies. So this user says, "Hi sir, good day. My family with an F2B category visa has been documentarily qualified since 2021. My eldest sister was under 21 when that happened. I was 19 when it happened. It's now 2023 and still got no interview. I and my sister is way past 20 years old. Okay, does this mean that we are no longer qualified for a visa even though before we turned 21 our case was already documentarily qualified? My mom is the principal applicant." Okay, that's a fantastic question. So I would highly recommend checking out the video that I've just uploaded yesterday. Is this video right here. Understanding Child Status Protection Act, the CSPA. So in your situation, it's a little bit tricky because it's F2B category, and for family preference categories, it is a little bit different whenever it comes to the CSPA compared to the immediate relative category. For immediate relative category, I'm gonna start with that so that you understand the difference. In the immediate relative category, whenever you're petitioning for someone and they are under 21, kind of, take for example similar situation to yours, right? You were like close to 21 but just under 21 when the application was submitted, and then while waiting you already turned 21. So in immediate relative categories, that under 21 age, once the petition is filed, that age freezes. So that's it. Even if you are 25, which it doesn't take that long for immediate relative categories, but even if you are, it doesn't matter because the age is frozen once the I-130 initial I-130 petition is accepted by USCIS. Not even approved, accepted. Okay, and that is thanks to that CSPA. Now, in family preference categories, it is a little bit different. You can take advantage of the CSPA, but only by subtracting the amount that I-130 petition was pending. So in your situation, if the initial I-130 petition was pending, let's say for a year, all right, then you can subtract that year when the immigrant visa is available from the total time that you were waiting from your age. So let's say, right now, let's say you're 22 and your I-130, just the I-130 petition, not the whole process, not the waiting for the immigrant visa, just the I-130 petition. If it was waiting for a year, you can subtract that year from your total age, from 22 years old, the whole year, 21 years old, and take advantage of that CSPA. So your age is not frozen because it's family, and for some reason it's this dumb regulations. Honestly, it should be the same for everybody. Just because I'm explaining it, please don't think that I justify it. It's ridiculous. It should be the same for everyone. But this is the way, the immigration system, whenever it comes to families, family reunification right now is set up. It's not very fair, unfortunately. But in your situation, I would definitely recommend a few things. Looking at how long the I-130, initial I-130 petition was pending for. If it was pending for a year, year and a half, then you have that year and a half to subtract from your age that you have right now to kind of take you back to that child status according to immigration services, if that makes sense. And then another thing that you potentially can take advantage of, which honestly I think would be the best case scenario. If your mom, she's a principal applicant, she's a petitioner, if the time has come for your mom to become naturalized, then once she gets naturalized and the petition upgrades from F2B to F1, obviously it's not going to be F1 now, but because the petition was originally submitted back when you were under 21, it's going to upgrade to the immediate relative category because the age would be going from when the initial petition was submitted and would count as immediate relative category. And again, all of that is thanks to that CSPA. You can find more information on it from that video. There are links specifically for the CSPA page on the USCIS, and also the legislation itself if you want to dig into it. But that would be the best case scenario if it's possible to convert the categories, from the permanent resident for your mom to U.S. citizen, and then obviously have your age frozen instead of dealing with all of this right now that you're dealing with. And I'm sorry, it's a long answer and there's a lot of stuff involved. Hopefully it's understandable. But if you have any follow-up questions, you're more than welcome to ask them here. Just make sure for everyone who's asking follow-up questions, don't ask them in response to my comment here. Submit them as a separate comment, because if you respond to my comment within your comment, YouTube does not send me that notification for some reason. Okay, moving further to View LTD, my son's case at NVC, and he's turning 21 after 10 months. Can we expedite his case due to aging out? View LTD, thank you very much for asking. This is a great question. So whenever it comes to expediting cases, there's two requirements that must be met in order before you can submit that expedited request. It is documentarily qualified already and immigrant visa already available. If those two are met, and I know it's ridiculous because most of the things that we wait for as immigrants is, the availability of the immigrant visa and becoming documentarily qualified. And once you are documentarily qualified and your immigrant visa is available, there's really no point to expedite anything because, that's it. It's the end of the process. The only thing that's left is the interview, and the interview is already scheduled when the immigrant visa is available. It's ridiculous, but that's what they require. So basically the answer is yes, you can, but it's kind of pointless. But again, for you, just like with my previous response, definitely take a look at that CSPA video, Understanding Child Status Protection Act, because again, if your son is in the immediate relative category, then his age is frozen, so no worries at all. But if it is in one of the family preference categories, F2A most likely, or possibly F2B, in that situation, yes, of course, you will be dealing with a little bit of back and forth, a little bit of calculating how long the I-130 petition was pending, like I was explaining to the previous commenter. The only thing that I didn't mention during my previous answer is that to take advantage of that CSPA, one of the conditions is that child who's over 21 must remain unmarried. If you got married, then that's it. You can't take advantage of that CSPA because that's it. You can't fall under the definition of child according to USCIS, according to the Immigration Service, Department of Homeland Security. Okay, so let's move on to the next question from Humphrey Igbokwe 7772. My wife is a nurse seeking FB3 visa category and has gotten documentarily qualified from NVC but affected because retrogression. Please, what is stand based on the July NVC visa bulletin? So FB3, F3 family-based third preference category. Let's take a look at the visa bulletin and see what is going on. So right now, according to the graph A, which is the final action date, which is when the immigrant visa becomes available for F3, all chargeability areas is December 2008. Okay, so December 2008, which honestly is a little bit strange. Why is so I'm assuming you don't have a status of a permanent resident or a U.S. citizen. Because if you had a status of permanent resident or a U.S. citizen, you could have applied for your wife yourself, and if you were a permanent resident, then it would have been F2A, much faster. If you were a U.S. citizen, it would have been immediate relative category, even faster than that. So I'm assuming you don't have permanent residence or U.S. citizenship, so it is her parent that is petitioning for her. That's why it's F3 category, unless you made a mistake in your comment. So for F3 category, currently it is December 2008. So the wait time is about 15 years. 15 years for F3. So it's quite a long time. So depending on when your priority date is, her priority date, you can calculate from that. So if you want, let me know in a follow-up comment, chargeability area. Again, please put the preference category just so that I don't forget, and then the priority date, and then I will be able to take a look at the visa bulletin and give you maybe a little bit better estimate. Okay, let's move on to the next question from Midnight again. I think it might be the same question. Let's see. Hello, I'm a U.S. citizen and filed I-130 for my brother in 2010. I've been checking my status on the website and it's been approved since March 11, 2011, and it's been stuck on the step for years now. During the time of approval, I had got the I-797 notice on action, and it says that the case has been sent to their office and is processing at the Vermont Service Center. From what people are telling me is that my case should have been sent to NVC, and they should have sent an invoice number and case number a long time ago. Is that true? I just want to make sure nothing happened along the way. Okay, Midnight, you know what? If you want, I would recommend submitting an NVC inquiry and letting them know that you never received your invoice or case number from them. and seeing if they can send you. Because yes, it is true, most of the times you do get a notification from the NVC. You don't have the full access to the NVC portal, but you do get the case number and invoice number. If you didn't get any of this, yes, I would recommend reaching out, submitting a public inquiry form, and I'll show you where to find it, and I'll put it in the link here so that it's easier for you to find it. So from this page right here, which is the visa bulletin for July 2023, you can find that link in the description below. At the very top, you will see contact us right here. So I'm gonna open it in new tab. And it's taking forever to load today. The extra long today it's taking, it's probably Saturday, that's why. So I'll scroll down a little bit more and you'll see US visas contacts right here, this one. So we're gonna click on this, and then you'll scroll down a little more, you will see the table. At the very top row, you will see email public inquiry form right here. So we're gonna click on this, and then you'll scroll down a little more, then you'll see online immigrant visa inquiries only, public inquiry form. Click on that, and there you go. You will have your public inquiry form, which here you don't have your NVC case number, so you will put your USCIS receipt number, which you can find on your 797, principal applicant's full name, that will be beneficiary, and then principal applicant's date of birth, beneficiary's date or date of birth, petitioner's full name, that's the person who filed the petition for you, the I-130 petition. Who are you, beneficiary or the petitioner? Here you can answer that. Your email address, and then your inquiry. In your inquiry, just say that, hey, you know, I understand that my visa, my immigrant visa is not, my priority date is not current yet. I'm still waiting for the availability of my immigrant visa, but I have never received in 13 years, you know, of waiting, I have never received any correspondence from NVC. And I was I suspect that it might have been missed. Maybe it was sent to the email and it got lost. Maybe it was sent as a physical, by mail, a letter, and you never received it. It got lost. Say just that you just wanted to follow up and see if they can send you the case number and the invoice number for your NVC portal. Because yes, most likely your NVC portal is still locked and you cannot really do anything there. But you should be able to at least log into it and should at least have the login credentials. Okay, so let's put this here and we're gonna move on to the next comment from Sunrise GP3YM. First, I would like to thank you for answering my question. I will keep asking you until my brother's coming, if that's okay. Absolutely. My question for today is, what's the difference between petition principal and applicant? Okay, so it's three different things. Petition is the application itself, is the petition, I-130 petition. Principal, there's a principal applicant and there's a derivative applicant. So there's two, it's not the difference between principal and the applicant. There's principal applicant and there's derivative applicant. Principal applicant is the, you know, main applicant on the petition itself. Like for example, beneficiary in your situation, if you're submitting the I-130 petition, if you're the petitioner, you're submitting the I-130 petition for a principal applicant who's the beneficiary. And then the derivative applicants on that petition would be, you know, spouse of the principal applicant, children under 21 of the principal applicant. So hopefully that's understandable. All right, let me post this and we're gonna move on to the next question from Paula Dome 7324. I am documentarily qualified since November 2022 and my priority date is May 2016. My dad is a US citizen and filed for me. I am over 21 years and unmarried. I will like to know if I'm supposed to send a copy of my new passport since the passport I submitted to them got expired yesterday. Thank you. Paula, that's a great question. Thank you for asking. So you're documentarily qualified November 2022 and your priority date is May 2016 and you're over 21, so that's F1 category. Unmarried, over 21, F1 category. So let me take a look at how long you have up until availability of the immigrant visa. So right now we have December 2014, so pretty much January 2015, so 2015, and you are in May 2016. So you roughly have another year and a half before the availability of the immigrant visa if you're in all chargeability area. So year and a half and you're already documentarily qualified. Really, there is no point to send anything updated to the NVC. What I would recommend doing is, if you do need, you already have the new passport. But you probably already do have the new passport because your old one is expired. So what I would recommend doing is, you most likely have the copies that you have submitted in the electronic version to the NVC to become documentarily qualified. Just make sure to have them when you go for an interview, to bring them with you of your old passport that was initially updated to the NVC where you became documentarily qualified. And then obviously have a new passport with you, and then, you know, once they ask for your passport, then you will be able to present the copies of the old passport that you were initially documentarily qualified yet with, and then for the actual immigrant visa, you will be able to give them the new passport, and obviously they can understand that, you know, things like this, like passports, they get expired and you already have the new passport, it's not going to be a problem. But right now there's really no point of going back and reopening the NVC portal. I don't even think they would do that for an expired document anyway, because they understand themselves that things like this happen. Just make sure to have the copies of the old passport when you go for the interview. In fact, I recommend everyone, whatever it is, tax documents, like for example with tax documents that you're going to bring for the interview, bring all the same copies that you have uploaded to the NVC portal in one folder, and in the separate folder bring all the updated stuff, because you will be waiting for another year and a half. In a year and a half, petitioner, they will have, your dad, he will have new tax returns. So bring the new tax returns in a separate folder, and bring the original tax returns that were uploaded to the NVC that you were documentarily qualified with. And the same thing with the passport, obviously. Okay, let's move on to the next question from Rolaji Bravo 623. Hi, I'm from Jamaica. I am I-130 F1. Started filing 2018. How long before I hear something from USCIS? Thank you in advance. So June 2018. 2018, exact priority date. So I think it's Rolaji or Rola. Rola, thank you very much for your, I'm going to say Rola, and apologies if that's not the name, but thank you very much for your question. So let's take a look again at the visa bulletin. I think I said it's December 2014. You're from Jamaica, so it's all chargeability area. I believe it is December 2014, so almost January 2015. So you're roughly looking at another 3.5 years before the availability of the immigrant visa. So 3.5 years for the availability of the immigrant visa. But let's see when the NVC portal is going to be opening up to become documentarily qualified. And here we have September 2017. So that is about your June 2018 and September 2017. So a little bit over a year and like through June, July. So you're in July, right? No, you're in June. Oh, well, almost July. So July, August, September. So about a year and 3 months until your NVC portal fully opens up and you can start your documentary qualification process. And then I think I said 3 years to the availability of the immigrant visa. So whenever it comes to the approval from USCIS, usually most of the times they hold on to the application closer to that graph B when the NVC portal is opening up, so that they have time to review the application, approve it, and then send it to the NVC. So you will probably hear about on your application, I would say in the next, possibly by the end of this year, but definitely in the beginning of next year, you should hear back from the USCIS on the decision on your I-130, and then in the next year and a half, you should have full access to the NVC portal to become documentarily qualified. Okay, let me pause this, and we're gonna move on to the last question for today from, got a few multiple questions there. Shafali 9. Hi there, I am US citizen. I applied for my sister in 2007 February and I got approval in 2008 and now waiting for her immigrant visa. She lives in India. When I originally applied for her with family, it was her husband and 2 minor kids. But her husband passed away and she's thinking of remarrying. In this case scenario, how can we update NVC also? Will it be better if she remarry now or after she gets her green card? Thank you for your help. And then priority date is February 2007 and it is F4. Also, how much time more do you think? Thanks. Okay, Shafali, thank you for your question. So let's take a look. So it's India. So India has their separate chargeability area. Let's take a look. F4 and we got February 2007. So let's see, F4 for India and we got 2007, so September 2005. So roughly, so it's February 2007, so it's beginning 2007, and then 2005 September. So you have about 2.5 years, roughly, for the availability of the immigrant visa. So let's see. Is she already documentarily qualified when I originally filed for her? But in this case, how can we update NVC and will be better? So you didn't specify if she's already documentarily qualified yet or not. I'm a US citizen, applied for got approval 2008, and now, but you got an approval 2008 for I-130. So potentially you might have had already submitted the documents to the NVC. So it's very possible that you're already documentarily qualified. Let's take a look at February 2006, and it is 2007. Okay, so possibly documentarily qualified yet. So if you're already documentarily qualified yet, you definitely want to contact the NVC, submit the public inquiry form with the NVC and let them know that things change and that you want to make an update. And obviously, it's not up to me to recommend, when it's better to marry earlier or marry later. But keep in mind that if she marries now and if everything is updated with the NVC and she goes for an interview, then her husband, obviously her children who are under 21, unmarried, they will be going as derivative beneficiary on the application, and her husband will be as a derivative beneficiary on the application. If it's not updated, then later it's it might be a little bit more of a hassle to add him as a derivative beneficiary. So it is definitely in this situation better to do it beforehand, before going for an interview, if she's not documentarily qualified yet. Because if she's already documentarily qualified, then obviously the portal is already locked and it might be a little bit more of the procedure in order to open it up. So it really depends if she's already documentarily qualified or if she's not documentarily qualified. But regardless of that, I would recommend reaching out to the NVC and updating them. And yes, I don't want to recommend that, but yes, it's obviously better to have all of the information updated with the NVC and be part of that documentary qualification process before going the interview, so that they already have the correct information that that there are derivative beneficiaries that will be involved on this application. So hopefully that's understandable, and I'm gonna post this right here, and then like I said, you're roughly looking at let's see, your February 2007, and the availability of the immigrant is September 2005. So there's roughly another February 2007, September 2005, roughly 2.5 years, 2 years roughly, because my math is horrible and I don't want to ruin it by getting the month involved, but roughly 2 more years before the availability of the immigrant visa. Actually, it might be less because it is September and she's in February, so might be like 1.5 years before the availability of the immigrant visa. So thank you everyone for watching, and hopefully my answers were helpful. Let me know if you have any follow-up questions and I will be happy to address them. As always, thank you for your time. God bless, and I'll see you all in the next video.